this incredible presentation by Judge de Blasi on best practices in joining and drafting arbitration clauses. Sharon, would you like to do the intro to NAM and the CLE requirements?
I will. Thank you, Rudy. Good afternoon and welcome to the NAM Academy. This program is being recorded, so if you don't wish to be recorded, although your faces are not seen, then please log off there. Today's program, Best Practices in Drafting Arbitration Clauses, will be presented by the Honorable John P. de Blasi and Rudy Rivera. Honorable John P. de Blasi, retired, is the former presiding justice of the Commercial Division of the Supreme Court of the State of New York. He has arbitrated and mediated more than 3,000 cases with an ADR practice focusing on resolving commercial, international, finance, employment, entertainment, land use, and professional malpractice matters. Judge de Blasi is available to arbitrate and mediate cases throughout the United States. And Rudy Rivera is the Chief International Counsel for a Fortune 500 company. He has had extensive international litigation and business experience in Latin America, Europe, and Asia. He has opened as well as managed several operations outside of the United States, and his areas of expertise include risk analysis and mitigation. Rudy is also an adjunct law professor at the Washington University School of Law, St. Louis, and is a member of the National Association of Corporate Directors, as well as the executive board member of the Association of Corporate Counsel. For those of you seeking New York CLE credit, you should all have received an email earlier today with a link to the attorney affirmation evaluation form and the handouts for today's program. If you haven't, no problem, you just email and I will send it to you. As a reminder to all those seeking CLE credit, you must remain logged on to the CLE webinar for at least 50 minutes to receive New York CLE credit. Please be sure to note any CLE codes announced during the program and record them on your attorney affirmation. And feel free to submit any questions you have through the Q&A feature located at the bottom of your Zoom dashboard. With that, we'll turn it over to the presenters. Judge de Blasi, Rudy.
Okay. Thank you, Sharon. Thank you, Judge. And Your Honor, you and I have had extensive background in litigation, and we're often forced to litigate what other people drafted. And what I've noticed is in drafting arbitration clauses, oftentimes not a lot of thought and energy is given to what does it mean in the event people break up. And do you find the same thing, that they just throw in clauses in there willy-nilly without thinking of how it's going to be enforced?
Well, I think what transpires is obviously at the inception, we have transactional lawyers who are representing clients who want to get a deal done. And one of the things that I've recognized during the course of my career and lecturing about this issue is that that's sort of a factor in terms of how the agreement is drafted initially. And sometimes there are provisions that I would say should be in every arbitration agreement that are not put in for business reasons. But at the end of the day, I first started arbitrating cases and I started coming up with this type of situation where we had a contested arbitration clause. I used to call myself the end user, but now I view myself as the arbitrator who's the end victim, because now I'm in the unenviable position of dealing with a situation where I have to make a determination as to the applicability of the arbitration clause, and or that dispute is taken into a state or a federal court and removed and eventually comes back to me. If in fact all of the provisions that you need in the agreement are not set forth in an appropriate way, you wind up with a litigation potentially before the arbitrator on this issue, a litigation potentially in court. And I guess my point with that is at that juncture, really the whole benefit of the arbitration process is lost. And I don't know, Rudy, you've been saying that?
I see it too. I see business units wanting to get the deal done. They don't ever think they're going to break up. The transactional lawyers are negotiating the agreement. And oftentimes, arbitration clauses are default clauses. There's a contract software that comes in that throws it in there, and that's the way it's going to be. And so I see it as an issue because we're going to go over some of the best practices, but the moral of this part of the story is give a lot more thought to the arbitration clause. And so with that, we're going to go over like some of the best recommended techniques or some of the best recommended practices. And I think one of them, Judge, is really decide what institution you're going to use, right?
Mhm. Absolutely.
Or whether it's going to be an ad hoc arbitration. I can tell you from personal experience, ad hoc arbitrations are much more dangerous to do than say an arbitration with an institution. How much
Well,
time should go into that? Yeah.
You know, Rudy, you asked me a good question yesterday when we were talking in advance of this program. It's what do I see as the biggest problem with arbitration clauses? And initially, I really sat back and I said, I really have to think about that. And I thought about it overnight, and I came up with, and I think what you're talking about is in terms of selecting an administrative process as opposed to doing it on your own. There are three big problem areas that I think are confronted when you're drafting a clause. The first, I would say, is lack of clarity. A lot of these clauses become so intensely complicated that they're almost impossible for the arbitrator to interpret. The second part is the failure to address all contingencies, and I think we're going to be talking about that. We're going to be talking about the administrative process versus an ad hoc process, venue, law. I know Rudy and I were talking about that yesterday, how dangerous this issue of what will the applicable law be. But the third thing that I see is problems which revolve around an inability to enforce the arbitration clause. And that is part of, from speaking to transactional lawyers, problem that arises out of the business deal, because if the enforcement mechanisms in the arbitration clause become too draconian, it may put off one party and cause them not to go through the deal. But I'll just give you an example of a scenario that I have as to how this can really break down. I had an arbitration that started as a party arbitration, which I would never recommend anyone to get into, because you have one arbitrator selected by one party, the other selected by the other, and then you have the two arbitrators select the third. And in the case that I had, I was appointed, another former judge was appointed as the other arbitrator by the other party. And what transpired is the other arbitrator could not gain the cooperation of the appointing party to come to some type of an agreement as to a list with respect to who the third arbitrator would be. And this process really stymied the entire arbitration process for almost a year, until my appointing party said, they're in default, you move forward and appoint the panel. And you can imagine what position that put me in. Now I have to appoint the entire panel. And what I did is I set up a wall. I didn't speak to the other arbitrators. As NAM was administering the process, I said to them, please put out this query to the other arbitrators on our panel if they would be interested in participating in this case. And ultimately, two other arbitrators essentially selected themselves. And now we get into the arbitration process, and guess what happens? The first challenge is to the constitution of the panel. How could de Blasi, essentially cause this process to go forward and cause the panel to be created? To which I responded, I don't even know these two arbitrators. I didn't select them. They were selected randomly, and they agreed to do this. But what that generated was an initial litigation in the California state courts over the constitution of the panel. Then we go forward through an arbitration process that takes approximately a year and a half, with a 2-week hearing in Los Angeles. And after that process is over, and actually during the process, there's a separate challenge to the arbitration agreement. And Rudy again brought this up yesterday with respect to how dangerous it is, what law you pick. And the challenge in the state court was, well, the commissioner of insurance in the state of California has to approve any arbitration agreement between parties who are in the state of California. At that time, the law in the lower courts in the state of California was that doesn't apply to the arbitration agreement. Well, guess what? Immediately after we rendered a final decision and judgment in the case, California, their Supreme Court comes down with a decision that's completely the opposite of every other case law that was out there. And they find that, yes, if the agreement wasn't approved by the Commissioner of Insurance in the state of California, the agreement is invalid. And this is after a 2-year process. So, Rudy, I turn it back to you. And that was your point about state law.
Well, and it's not just state law, it's anywhere internationally. I mean, you have two issues there. how do you select the arbitrators? You know, it's a beauty contest sometimes. I've seen arbitrators that say, oh my God, these guys are the best in the world and they're the biggest putzes, okay? And there's a new service out, you know, Juice Mundi, these young guys, millennials set up this service where, you know, you can research now arbitral awards, you can research arbitrators now, like you can with judges. And so that's probably a new tool added to the mix on how to choose these people, because choosing them is also an important process in drafting the clause, right? You have to decide who they're going to be. If they require special expertise, if it's an IT case where you need somebody that has to have IT knowledge, or somebody in finance or whatever. In some cases, arbitrators are not even lawyers, okay?
Sure.
So the big decision, is it a 1 or 3 panel and 3-man panel? And that really focuses on how big the deal is, right? How big the breach could be. And that is, you know, another important consideration. That's one of the practices. What's is it going to be 1 or 3 panel? I mean, person panel? And then what are the rules? If you're going to have a whole lot of discovery rules, you might as well litigate in federal court, right? The whole purpose is to streamline it, right?
You're absolutely right. And I think one of the points that we made during the course of, you know, our discussion is, again, this issue of who's going to administer this process and how are the arbitrators going to be selected. And my recommendation would be that if you're drafting an arbitration clause, the ADR provider should be agreed to. You should always have an ADR provider that is agreed to, and you've agreed to select arbitrators from a specific panel. And the parties usually can come to an agreement on that. We have in the outline that I have the issue of unconscionability. And of course, there are times where parties are, in terms of position, one is far more powerful than the other, and they force upon the other an agreement. One agreement that I saw where there were 2 potential panels that could be used to pick the arbitrator, 2 potential ADR providers, 2 potential sets of rules that the ADR providers could use. The venue of the arbitration was anywhere in the United States. And under those circumstances, the courts or the arbitrator are certainly entitled to either declare the entire arbitration agreement unconscionable, or in the alternative, what can be done is, what is more usually done is that certain provisions are stricken from the arbitration agreement. But I agree, it's extremely important, you know, in terms of the first thing that you're going to be doing is, where are we headed down the road with this? If we do have to arbitrate, who is going to arbitrate this case? What panel are we going to use? And my recommendation would be selecting an ADR provider and agreeing to their rules. Now, certainly, all ADR providers have rules for arbitration, as NAM does, and you're certainly free to modify them with the consent of the parties. But I agree with Rudy, you know, this is a critical part of the process, and it should be set forth clearly in the arbitration agreement.
Well, and one of the other issues that comes up is where the arbitration is to take place. So you have A, the seat of the arbitration, and B, what law is going to apply. And what you have to take into account there is that the arbitral award has to be enforced. Right. And where it has to be enforced would really depend on what service provider you use for this. Some countries follow, you know, the Chamber of Commerce rules. There's all kinds of rules. And you have to look at who's a member of the New York Convention, who's not. All those things. Otherwise, you're going to have an award that you cannot enforce possibly in a country.
Right. You're absolutely right. And that's why specificity with respect to venue is critical. Specificity with respect to the law that's going to apply, that's critical. And also with respect to the location of the arbitration itself. And I have seen arbitrations where the location, the simple location of the arbitration turns into an incredible fight between the parties. It's easy enough to specify that the arbitration is going to be held in a specific location, that a specific set of laws are going to apply to it, specific set of rules are going to apply to it. And, you know, my recommendation would be, you always have to get out ahead of that and think about, you know, well, what happens if we have to arbitrate? Where is this going to be? What laws are going to be applied? And then another consideration is this, in terms of selecting the applicable law, assuming it's in the United States, what state law do you want? There are obviously extreme differences between various states in terms of what their rules are pertaining to arbitrations. And additionally, one of the things that differs from state to state is if you have judgment and interest can be added on to whatever judgment is granted, assuming it is by the arbitrator. Different states have different interest points in terms of what can be added to a judgment. And one thing I just wanted to jump back to that I mentioned that is, I believe, is critically important. There has to be an enforcement mechanism in the event one party or the other fails to abide by the agreement and or the rules of the ADR provider. And this is in speaking with transactional attorneys where a problem comes up. And I think I mentioned this earlier with the client. The client doesn't want to blow the business deal. But I really believe that if in every stage of the process, you have to have something in place to enable you to obtain a default, whether it is costs and disbursements, and you have to have that almost at every stage of the process as a fail-safe. In other words, an all-encompassing provision for some type of penalty in the event one party or the other fails to cooperate, because otherwise what you're going to be doing is going into court to attempt to enforce it. Rudy?
Well, I agree. And one of the reasons for being clear with that is not just in the States, but also outside the United States. Every country has a mechanism for setting aside an arbitral award if it violates public policy, for example. I mean, generally, a business deal that goes south, or basically there's a dispute, is not necessarily going to be that something that's against public policy. But I think one tip, and I've recommended and I've done in the past, is if, for example, you are going to arbitrate and you have to enforce the arbitration in Mexico, and you have a contract, say, with a Mexican entity, you know, if you have the arbitrators apply Mexican law and you win, then it becomes difficult for them to say that is against Mexico public policy or against, you know, public policy in Brazil or any other place. You've taken a leg up, because many people don't believe that it is. They think it's a slam dunk when it isn't, you know?
Absolutely. And one of the things that we're talking about, and I just want to mention, I know that in speaking with Sharon Peterson, my understanding is that all of the parties who are attending the seminar will get an email with a link, and that will contain, I guess, a substantial number of articles and other printed materials about this process. So just so that you're aware of that, you'll be able to download that materials. But one of the things we talk about, and I have to say, a attorney who was discussing this with me brought it to my attention. I never really thought about it. And he said, I said, well, you know, arbitrations are confidential. And he said, well, they are if you have an agreement. And, you know, that was a good, I always say, you know, I learned something every day, and I had never looked at it. That, you know, you have to have a confidentiality agreement in place in the arbitration clause itself. And here's really the catch-22 in this situation. Parties, typically speaking, want to arbitrate a matter because whatever is transpiring in their business relationship is going to be confidential, and it's not going to be public. And this is something that's critical for the parties in almost every arbitration that I have that deals with two businesses. The problem is, if you wind up litigating the arbitration clause, the benefit of confidentiality is lost. If it winds up in the courts, it's all lost. It's all going to be there. It's all going to be part of a public record. So the idea is to avoid the challenge with respect to the confidentiality agreement, not avoid the challenge of the clause being taken into a state or federal court. But also, one of the things that I've thought about, and what I would suggest, is that there be a specific clause in the agreement saying that you can't take it into court, that it has to stay within the arbitral process. and you agree that on any issues, including any challenge to the arbitration clause itself, that it will remain within the arbitral process. One of the things that I've seen is 9 out of 10 times when the proceeding is brought in a state or federal court to challenge the clause, maybe cynically, I usually believe that it's an attempt to delay the process, which is another factor in the situation. So my recommendation would be, and some people are worried about this, they don't want to waive the right ultimately to go to court. But the fact of the matter is that that would probably be beneficial in most cases, because in the majority of times that a challenge winds up in court, the state or federal court judge 9 out of 10 times refers it right back to the individual arbitrator or right back to the panel to make the decision. And Rudy just touched upon it. Rudy, from your perspective, the benefits of a single versus a tri-panel versus a party arbitration, you have any preferences on that? Because that goes back to selecting the arbitrators and how this is going to be set up.
I think it really depends on the matter. I mean, the reality of it is that, we've got one neutral and 2 party appointed arbitrators, and that's supposed to be the balancing act, correct?
Right.
It prevents an arbitrator from going rogue, because an issue with I used to say it's a problem, but I'll say it's an issue, is that you have an arbitrator that goes rogue and makes a decision that seems to be off the reservation. It's hard to get it reversed. It's very difficult to get an arbitral award reversed. However, I think that it's one of those issues that you have an arbitrator that, hold on, I think it's one of those issues that you have to really think long and hard about. Because if you have a dispute that's $500,000, you don't want to go to the expense of a 3-person panel. So you want to be more careful on the person that you select, okay? On the other hand, I see a lot of value in having the person that you pick. That's the counterbalance, right, to somebody going off the reservation. So I would be reluctant to ever do a 1-person arbitration again, strictly for that reason. And we do have a question. I frequently see arbitration clauses in agreements, but also provisions adjacent would talk about waiver of jury trial and jurisdiction for litigation. What's the best way to handle that? That's a very good question, and that's
we're talking about that yesterday.
Something I just encountered, and that is that in some states you are not allowed to waive a jury trial. And I believe anyone licensed in California can tell me, but I've been advised by California counsel those provisions waiving a jury trial are unenforceable. Okay, so you have to be careful with that. The second thing is the jurisdiction for litigation. So what I see happening there is that there are contracts that have been used that had a litigation component. They agree to arbitration, but they still have some of the jury waiver clauses and litigate in New York federal court if we have to. I think it's dangerous to have those things, because if somebody decides that they want to not do the arbitration, those clauses are giving them ammunition to say, you see, we did not intend to arbitrate every dispute.
I agree with you completely. From my perspective, why enter into an arbitration agreement if it allows for the possibility of one of the parties going into court to challenge any part of the process? And one of the things that you can do, obviously, and I've seen it in any number of cases, there can be a process for an appeal from the panel's decision or for the individual arbitrator's decision. Not that I would necessarily recommend that, but sometimes parties are concerned about that. But I've had arbitration clauses which will say either with a single arbitrator or a panel that there can be an appeal to another separately appointed panel with respect to any issue. I agree with Rudy. I think the type of arbitration panel that you select is going to depend upon the case. And I also agree that I think with cases where the expense just does not warrant it, and specifically the expense of having 3 arbitrators doesn't warrant it, it's fine to go with the single. From my personal experience, I do many arbitrations where I'm the sole arbitrator, but honestly, I enjoy being on panels. there's great value when you have a panel to having different points of view, and you're not being locked in as the sole arbitrator. And again, not that I walk away from that, I do it all the time, but I actually will tell you I've enjoyed the process far more when I have colleagues who are there and can give contrasting points of view as to any number of issues. Personally, I did not like or do not like the party appointed process because it always creates issues. As Rudy said, there's this funny dynamic that you have two arbitrators who are being appointed by each of the parties, and then they're selecting a third arbitrator. And it's just an inherently difficult scenario to handle. So my preference is, I'm not saying you shouldn't do it, but from the arbitrator's point of view, I don't like party arbitrations. Single arbitrator I'm fine with. If you have a real controversy with a lot of money involved and it's complex, I think tri-panels are terrific, although, the cost obviously is going to be there. And then the other part of it is the logistics of getting three arbitrators together at one time is also difficult. Do you find that, Rudy?
Yeah, I think it is difficult scheduling, and the people who are super supposedly, I don't want to say good, because you never know anybody's good until you actually see them in action, but who are extremely popular and sought after have a calendar that's a ways away that you can't get on there. Right. And I think another practice tip is you don't necessarily have to get the famous people to be your arbitrator. It's somebody who's solid, who has an understanding of the issues, maybe just as well as somebody who's got the reputations. I found in my 40 years of practicing that relying on reputations can be very disappointing.
I would agree with that.
It can be. Go ahead.
Go ahead.
Well, we've got a couple questions. Have you ever handled Section 10 petition to vacate or Section 11 to modify? Are they truly rarely granted?
I have never had such an application. The majority of applications that I've seen post-arbitration usually wind up in the courts, and generally speaking, they're denied. That's been my experience. So I can't really say it beyond that.
Well, I had half and half. I had one granted where the award was completely vacated, and then the California Appeals reinstated the award. And so, yeah, but it's very difficult. I mean, there's a whole line of authority on setting aside an arbitral award. I mean, I use easy for lack of a better word, but if the arbitrator decides issues that weren't in the agreement, that's an easier argument, right? But as long as you can argue that everything is in the agreement, that this person's decided that, then, you're going to have a hard time getting it overturned, no matter how crazy the award is. Another question is, we usually have a carve out for injunctive relief to come from a court due to timeliness. Do you think that's a good idea? Yes, I do. If it's an enforcement provision, if you can prove irreparable harm, that you cannot be compensated by monetary damages, yes, it's a good idea to have that injunctive relief provision. Okay.
And you can also, another way of handling that is you can provide within the arbitration agreement for the appointment of an emergency arbitrator. I've had that role in a number of cases where the parties are seeking a temporary restraining order or preliminary injunction, and they're brought in very, very quickly. And again, in conjunction with this, I would mention that if you've chosen an ADR provider to administer the process, I know it's very clearly set forth in NAM's rules. There's a process by which the emergency arbitrator is selected. Generally speaking, they're selected by the ADR provider unless you want to agree otherwise. The idea being there's not going to be a fight over who the emergency arbitrator is. So I've had cases where I've served in that role, and I think it worked out quite well, because as opposed to going to court, I was brought in very, very quickly. And within a week or so of the application, there was either a hearing or not a hearing, depending upon how the case went. So you can insert that into your clause. But when I mentioned, this concept of rules, and I think we keep on referring back to that, and I said right now that NAM has very specific rules, as do all the other ADR providers, with respect to the appointment of an emergency arbitrator. I find that what very often happens is that parties will agree to a specific ADR provider and to the specific rules of that ADR provider, with the assumption that all ADR providers have the same rules. That is an incorrect assumption, number one. And then secondly, what I find is that many of the parties, when they're agreeing to this, don't really sit down at that early stage and take a look at what the ADR provider's rules are. Nor, in fact, I would say I've had arbitrations where there are applications at the inception or during some part of the arbitration, which are directly affected, we put it that way, by the rules that you've agreed to. Then there is shock when the arbitrator says, well, look, I'm constrained by the rules that you've agreed to with respect to my authority to do A, B, or C. So my point is, you have to be, in the first instance, very careful as to whose rules you're selecting. Read those rules, be sure you're familiar with them. If there is anything in those rules that you don't feel is appropriate for your client, the rules can certainly be modified. But if you haven't even looked at that, I mean, obviously, when you get to the stage where you're seeing Rudy or myself, at that point in time, read the rules before you come in. And, it seemed to be something that's so simple. But very often, people work on the basis of an assumption, and it doesn't turn out very well for them. I noticed that it's 1:30, and I know Sharon has to give the CLE code out. So Sharon, if you're there, I'll turn it over to you for a second. And if you're not there, we'll continue.
I am. I apologize.
No worries.
Coming right out now. Okay, there we go. Sorry. The CLE code for today's program is NAM arbitration. And just be sure to record that on your affirmation form. I also just wanted to answer, Judge de Blasi had mentioned something about the handouts. Yes, there will be, the NAM's rules will be included or are included in the handouts that you should have received, as well as all the other documents and a PowerPoint related to this program. Thank you.
Okay. Can you say that code again, Sharon?
Sure. The code is NAM arbitration. Thank you.
Rudy, have you run into problems where, there's been a agreement with respect to rules and then the parties come in and it becomes problematic, so to speak, at the arbitration stage?
Right. And where I see the problem is that nobody read the rules. And then it gets, what do you mean this? What do you mean that? What do you mean I can't do that? I think one criticism that the arbitration organizations or dispute resolution organizations argue is that lawyers complicate the matter themselves, and they want to treat an arbitration like a federal court litigation with all kinds of motions and stuff. And so I see that as an issue. I take a little different approach. I think that in terms of the injunction, I don't know, because I've never had to get an injunction during, with an arbitrator, but you can get into court on a TRO, temporary restraining order, like right then and there, get it granted. You have the hearing within 10 days. And if you need something really, really quick, where, for example, you have to stop a sale, you have to do something that requires immediate action, then going to that may or may not work. By the time you contract the agency and by the time the arbitrator gets appointed, I don't know if they have one on call, like they have doctors on call, but it may not be helpful to you. So I really think it depends on the situation,
It does. I think you're absolutely right. And then the other thing is, and we're talking about this, you have to have a confidentiality agreement in place. Don't assume by virtue of the fact that it's an arbitration, it's confidential. But we get back to the same conundrum. If part of your purpose in going to arbitration is to keep everything confidential, and then you wind up in court seeking injunctive relief, the purpose for entering to the arbitration, I would assume that it's being confidential. Now you're going out into the court system and it's becoming part of the public record, so to speak. I mean, that's the consideration, but I agree with Rudy. It also depends on what the process is for appointing an emergency arbitrator and whether you think you can live with that, or whether you prefer to go into court, and at that point in time, you know, the confidentiality aspect really just doesn't mean it. But Rudy, how about streamlining the process? I know we often talk about that.
I'm a big believer in streamlining the process. When it comes to major disputes between big companies, say it's a contract dispute. I mean, the documents, number one, are going to speak for themselves. You know what people on your side are going to say. You probably know what the people on the other side are going to say. So I'm more in favor of streamlining it, getting into the arbitrators with it, and moving on. Because if you start sending interrogatories and taking depositions, I mean, in this day and age now, where especially with major companies, everything is saved, right?
Right.
And you have legal holds that say you have to hold it. You know what evidence you're going to have, right? And if you're getting into the arbitration, you know you're going to get into the arbitration, then you do your investigation before then. So before you invoke your arbitration, have your evidence ready. Don't invoke it and start looking for the evidence. So I think it streamlines it. I think streamlining is better.
I agree. And one of the things that I would say is if you're involved in a case where there is going to be discovery, and obviously it's very hard to say what your rules would be or what procedures you would follow to streamline discovery and make it as efficient as possible. But one of the things I might do is if you have a trial panel, if you have a tri-panel, I would specifically in the agreement designate whoever the chair is of the tri-panel, make all of the decisions with respect to discovery. So you don't have to convene the entire panel for a discovery dispute. And additionally, you may very well, although I will tell you the way it works inside a panel typically is the two other panel members on the discovery process, as well as evidentiary rulings during the arbitration hearing itself. Generally speaking, unless it's a major issue, are going to go along with the chair of the panel. But you may want to consider designating the chair specifically in the arbitration agreement if you have a tri-panel as to be the decider with respect to every discovery issue that may come up, and also with respect to the arbitration hearing itself, designating who is the chair of the panel, and usually the parties can agree to that, that chair will make all of the evidentiary rulings during the court proceeding. Rudy, have you had experiences with that in terms of having to assemble the entire panel if you have a discovery issue?
Yes. And it's a problem, And of course, we learn from our mistakes, right? We learn for things that go wrong and do it. Yeah, I've always found that as a problem. I would say that one of the other things you want to do is if you have to have discovery, limit the number of depositions. Have a finite number, maybe 3 on each side. Or whatever the appropriate number is, make sure you agree to that in advance. And something else I would say is that, and then it becomes specific, very, very important to define what is going to be arbitrated. Because a number of contracts have an arbitration provision, but say if you're a service provider and there's a lawsuit by a third party against you, that's not going to be arbitrated, right? That's, a third party suing you, and then you've got an indemnification between the other. That indemnification may need to be arbitrated, or it may be in the lawsuit itself, you have to indemnify me. You have to define those issues specifically, what needs to be arbitrated, because again, the arbitration is a creature of contract. And they won't go. And a number of contracts I've seen, or situations I've seen where people say, well, this isn't part of the arbitration. This is a separate issue. You have a contract, they say, well, this is a tort. And I think historically courts have said, no, if you're arbitrating everything. Is that your experience too, Judge?
That is my experience. And I think what this speaks to, and I was just thinking about it, is in terms of, the arbitrator who is in the position to make a decision. And I just had this thought because we were talking about selecting the arbitrator and who would be the best candidate for that. this is just something that I've thought about over the years, is probably you want an arbitrator who's going to be very efficient. And if they have a reputation for efficiency, I think that's one of the best qualities you can have. Because having attended a number of conferences, one of the biggest complaints that I've heard from attorneys with respect to the arbitration process is that we went into this process to ensure not only that it's confidential, more importantly, that it's an expedient process. And we have an arbitrator, we have a panel that takes so long to make any decision, and this is just going on and on and on. By the time that we completed this arbitration, we could have been in court and resolved the case. It really didn't benefit us to go to arbitration. So I think you need to look at, when you're selecting an arbitrator, and I really agree with Rudy, reputations, are reputations. And I often think when someone says to you, this person is a terrific arbitrator, well, they got a terrific result from that arbitrator. So they are inclined to say he or she is very fair and does a great job, whereas others may be inclined to say, I'm not satisfied with the process or what happened. But the other thing is, I think you have to, and this is again, you learn when you speak to other people, other attorneys who've been engaged in the arbitration process. And to me, it's fascinating because even though I was a trial lawyer, I was on the bench, and I've been an arbitrator, I don't necessarily see it the way you do. But one of the other things that I would say, and this was said to me by a partner from a firm when I was at a conference, he said, when we pick an arbitrator, we want an arbitrator who's going to be efficient and move forward, but who's not forgotten at one point they were practicing law and they were a litigator and an attorney. So that's another tip in terms of finding out or determining who the arbitrator is going to be during the course of this process. I think expediency and also finding out what their temperament is in terms of how they are counsel friendly, I should say, how willing they are to work with the parties to ensure an expedient and fair process. I think that's critical. Rudy, your thoughts on that?
It's important. I think sometimes arbitrators want to please everybody.
Exactly.
And they don't want to necessarily make decisions.
Right.
And in some instances, they could make a preliminary decision.
Right.
But most of the time, what I've seen is that, well, I'll just decide it with the case in chief.
Right. Right.
And if you can limit certain issues, why not limit them? So I think it's important to select an arbitrator that's going to take control of the arbitration and not just be a yes person to both sides to try to get consensus. Because obviously, one side's going to be happy, one side's not going to be happy. There's still that myth that arbitration institutions say, well, we don't divide the baby. There are a lot of people, and there's all kinds of stats to say we don't divide the baby. But I've seen where they've divided the baby. I'm sure you've seen where they've divided the baby. So it's important to get the person who can make a decision, who's known for making a decision. Now, practicing for 40 years and practicing as long as you have, absent some other circumstance, we know pretty much if we lose a case, why. Mm-hmm. If you don't know why you lost a case, then you didn't assess it properly. Now, I'm not talking about the red herring an arbitrator or judge throws at you. Okay, talking about if you lose, this is why. Mm-hmm. And so the fact that an arbitrator might rule against me wouldn't necessarily preclude me from using him in the future, provided that it is the opinion's well reasoned.
Exactly, and I completely agree with you. This is where it becomes fascinating to me when I'm in a tri-panel. Some of the things that take place, because in a tri-panel, of course, you're one of three, and you can't guarantee that everyone else is going to be on the same page as you are, have the same background. I think, having been a former judge, I've always said that the best former judge who is a mediator or an arbitrator has forgotten the fact that they ever were. They put it behind them because it's a different skill set that you have as a mediator or as an arbitrator. But one of the things you do have as a judge, if you were built this way, is the understanding that you have to make. And I think Rudy's exactly correct. I remember when I first started practicing law, there was one judge who I was trying a case before, and every evidentiary ruling alternated between one side or the other. It didn't make any difference if it was correct or incorrect, but it was like one for you and one for you. I'm going to split this down the middle. And I've seen that where arbitrators just don't want to either make a decision or to put their foot down at some point and say, listen, we have to move on with this. We have to really get through this. And the question becomes, at some point, I think Rudy makes such a good point, because I've had this experience. You're involved in a trial panel and you have to make a decision with two other individuals. And I myself, if I'm rendering as a decision as an arbitrator, and I could not agree more with Rudy, that I have to render a decision that really explains to the parties what my reasoning is. I think that's critically important in terms of selecting an arbitrator with respect to not only counsel, but more importantly, the client understanding why I rendered that decision. And I've seen oftentimes a hesitancy when you have a panel to really come out and say what it is that you're thinking. And I've experienced it on two panels that I had. One, there was a hesitancy to fully explain the reasoning behind the decision. Not that the decision was, opaque or didn't explain enough of the reasons, but it really didn't get to the heart of it, at least as far as I was concerned, as to why we were making this particular decision. So I think you're picking an arbitrator who's actually going to write a decision that you can take to your client, whether it's favorable or unfavorable. It explains the reasoning. But the other thing that I've noticed, and I've seen this on panels, I don't have a hesitancy, and maybe it's because I'm a former judge, tell it like it is. And if I don't believe someone, I will put it in the decision that I found a witness not to be credible, not to be believable, and I will cite the specific examples during the course of the testimony and during the course of the proceeding as to what my reasoning was, because ultimately that's critical in many of these cases. Who do you believe? And I found on some panels that there's a hesitancy among the panel members to come out and basically say this person was not. And I think it's very important if you really believe that as an arbitrator, and this goes back to selecting who you want on your panel. If the arbitrator ultimately believes that a party was not truthful, a party was not credible, or they have very specific reasons, it should be the type of arbitrator that's going to put it out there so that the client and you both understand what the reasoning was behind the decision. Ready?
Well, it's being transparent, right? Being transparent. My friend Manuel Del Valle, who's a professor of federal practice and a former administrative law judge in Puerto Rico, says American Arbitration Association research suggests that average arbitration cases take about 7 months, while average litigation can take from 23 to 30 months, depending on the court schedule.
Right. Absolutely true. At least in my experience, the arbitration process is going to proceed with the right panel far faster than the court system, particularly if you happen to be in the state of New York. Now, post-COVID, I think both in the state and federal courts, everything is so incredibly backed up that any expectation that you might have had pre-COVID versus any expectation that you may have now, even, for example, if you're in the commercial division of the Supreme Court in New York County, which is a very efficient division, they're so backed up with cases that I can say anecdotally, I'm seeing more and more cases of all types going to arbitration because the process can be expedited. So, I also think that attorneys are becoming less fearful of the process. As Rudy pointed out, I think was this perception among many lawyers, and I don't think it's necessarily unfounded, that sometimes panels look to, split the case evenly and attempt to more or less create a compromise. But by the same token, if you go into a court, you can't pick your judge. You don't know who your judge is going to be. Is that judge knowledgeable? Is that judge efficient? Is that judge a worker or not a worker? Does that judge like to try cases, or is the judge adverse to trying cases? At least in the arbitration process, you have the ability to select the type of person that you want to be making a decision. Rudy?
Well, and I know I agree with you. I agree wholeheartedly. But going on, the question I have on that is, does that count the arbitration process count from the time that you've picked the arbitrator you're going? Or do you include the time that you're deciding to arbitrate and you spend, several months trying to select the right person? I would tack that time on.
It absolutely has to be tacked on, and I think that goes back to what we were discussing at the beginning of this presentation, which is that there has to be real specificity in the arbitration agreement as to certain dates that are going to be markers in terms of what you have to accomplish, whether it is filing a petition at a certain amount of time and filing the response to the petition, whether it's if you have issues concerning discovery, although I'll put that aside for a second, very specific time limitations as to how long the parties have to select the arbitrator or arbitrators. It's particularly important. I think at the beginning I referenced the fact that in a tri-panel that I was in, there was a problem with one of the parties just stalling and refusing to allow their party appointed arbitrator to work with me to select the third arbitrator. Has to be, I think, Rudy, you're dead on with that. At this process, before you reach the arbitrator, before that party is even selected, that you have a process laid out from the very beginning that's going to move the, let's say, pre-appointment process as quickly as possible. And again, and I think I reiterate this over and over to people, there has to be some consequence if one party or the other fails to comply with the markers in terms of time with respect to things that can be completed, including and up to the ability of one party taking a default for failure to proceed with the arbitration project. So I agree with you, Rudy. That inception, arbitration begins from the day there's a petition and the day that petition trigger the process. I think that has to be very carefully planned out and plotted out. We can't tell you exactly every step you should take, but you should be thinking about, okay, if we have a dispute, what do we do at that point in time? Is there notice given to the other party? Do we give them time to cure? Very tight dates in terms of time. If we're going to go to arbitration, when does the petition have to be filed? When does the response have to be filed? How long do we have to select the arbitrator or arbitrators? Here's a tricky one. What is the process going to be to select the arbitrator? You basically can select an arbitrator or arbitrators as if you were selecting a jury and have a strike method where you get to pick three, they get to pick three, and then each side can strike the other until you get down to the ones that you're going to use. That all should be in the arbitration agreement, and you don't want to wait until the arbitration is filed to start dealing with all those considerations. So I think, Rudy, you hit a major point here, which I didn't even think of, but that's incredibly important to the parties in the arbitration process.
Should you specify the language? Usually in the US, it's not going to matter. It's all going to be in English. But when you have an international arbitration, you should specify the language. Absolutely.
Absolutely. All of these micro details have to be managed, and it's sometimes what I see is the micro details deal with a lot of language in the agreement, which really doesn't really help us. It just complicates the arbitration clause. But I think you're absolutely right. You've got to get down to the nitty gritty of every detail and look at what could hold this up.
Exactly. And so you have to be very analytical with this, because you are going to base the entire breach of contract, the entire litigation on what's drafted in what's usually 2 or 3 clauses in a very complicated agreement. Now, what I want to emphasize to our listeners is not that you have to have an arbitration clause 30 pages long, okay, but that the analysis to that arbitration clause may have to be 5 or 10 pages, because you've factored in everything to get it into a concise and term-specific agreement. Okay, that's, I think, is the issue. And so what I've seen is the thought here is like this, and then they enter this agreement, and that's where you have the problem. Something else that I would normally recommend as a best practice, and if you can do it, is when you're contemplating an arbitration clause in the agreement, also contemplate a pre-litigation mediation with the business units. Sometimes people just want to vent. And I think that's a very, very successful way to resolve a dispute. It's expensive to litigate, it's expensive to arbitrate, but if you can have the decision makers sit together and try to hammer out something, especially in a complicated, for example, IT agreement, where it could take months and months to implement a process and people are unhappy. And then you have an agreement that before you get into that mediation, that pre-litigation mediation, you can't invoke the arbitration unless you've had an opportunity to do that. And if the other side drags their feet within 45 days, then you file the notice of arbitration. But that goes a long way. You want to talk about economical, trying to resolve the issue. And the question you may have is, well, I don't want to say stuff that might be used against me, but you have an understanding that nothing to be used in this is to be used in court. I mean, that's kind of like a false, because you're going to say what you're going to say when you're presenting your view. It's going to be what you're going to say in court, right?
Absolutely. And I think you really make a good point. You know, as arbitrators, there's nothing wrong with an arbitrator, you know, asking the parties, are you discussing settlement? And that you're not going to become involved in that process, but certainly you can ask them at any point in the litigation process. And I think that is really a dodge. It's just a lot of times the arbitrator wants to know, you know, how is this proceeding? Where are we going with this? But I think Rudy, you know, makes a really good point. Look, it's always preferable if you can avoid any litigation process to settle the case. I mean, I think the best case is a settled case. It's less expensive, obviously, and particularly with respect to the business relationship. What I've found is by the time it gets to me in the arbitration process, the business relationship is shot. And what's really problematic is where you have parties who are tied to each other for a period of, let's say, 10 years, which I've had. And they're going to have arbitration after arbitration after arbitration, and it becomes basically a grudge match. I had an arbitration where I was completely convinced. I was on a tri-panel. We were made aware of the fact as part of the proceedings, which I didn't think we should have been made aware of, that had been a prior arbitration and the decision had been adverse to one of the parties, not on the same issue. And I was absolutely flabbergasted that nobody objected to the panel finding out about this. And to me, it was incredible. It's not something that we should have known, but it was a teaching experience for me because I'm looking at it as a whole and saying, well, these people are locked in for the next 10 years. That we're the second arbitration that they're going through. And this was an arbitration where the hearing lasted 14 days. And we're not talking about small sums of money. So the idea is if you can diffuse the conflict early on, and I agree with Rudy, you should have a pre-arbitration mediation process set up. But again, you have to keep the timelines very, very tight. I had one case, it was very interesting, incredibly complex case with a very, an incredibly high dollar value, staggering actually. But their arbitration agreement called for an initial meeting between the two teams from the respective companies. And then within a certain amount of time, if that didn't work, then there was a meeting between counsel of the respective companies. And then if that didn't work, there was a meeting between the CEOs of the two companies. And they actually went through this process by the time it got to me. And ultimately, the last meeting with the CEOs worked, and the prior meeting set the stage for the case to be settled, because had it gone forward in arbitration, it would have been just, in my opinion, a colossal disaster because of the complexity of it and the time that it would have taken to resolve it. But I think, you know, if you're thinking about preserving the business relationship, people start litigating with each other. It usually goes south very fast, and there's no ability to preserve the business relationship. I think in terms of looking or being forward-looking, when you're drafting the arbitration clause, I totally agree with Rudy. If you can get a mediation agreement there in before you arbitrate, that's an excellent idea.
It's difficult for an arbitrator to be a mediator, but have you ever seen a situation in an arbitration where they say, the arbitrator says, why don't you try to mediate this thing because you might be close?
Well, it's interesting. I always, it's very difficult to do that because what I'm always concerned with is if we say that, which you're not prohibited from saying, by the way, there are usually provisions that you have that say the arbitrator is always free to encourage the parties to resolve their differences and resolve the case. But my fear with that is that the parties may either A, take it as an indication that the mediator, or the arbitrator is going one way or the other, or in the alternative that the arbitrator or the panel really doesn't want to decide the case. So I've been very cautious about that. The last complex arbitration that I wrapped up very, very recently with two colleagues, and I thought that the chair of the panel, I was not the chair, was I learned so much from him and my other colleague who was on the panel. He did it in such a careful and diplomatic way that it was expressed to the parties that they did have the opportunity, even at this late stage, to attempt to resolve the matter without the panel deciding it. But it was done in such a way that there was never an impression given that we had decided one way or the other, or in the alternative that we didn't want to make a decision. And in that case, as we fully anticipated, the parties weren't agreeing to a settlement and rendered a decision.
Well, we're almost to the top of the hour. It's been, we could go on for hours on this. I would say some takeaways from today. It's very important, number one, to decide the institution that's going to do the arbitration. Look what treaties are enforced. Look, where you're going to enforce the arbitration, because that could decide which institution you choose. Okay. Give a lot of preparation to the drafting of the clause. The clause does not have to be long, but give a lot of thought to enforceability when you're drafting the arbitration clause. The number of arbitrators is going to be important. And what happens if an arbitrator gets sick? You need to have a mechanism for replacing the arbitrator, or all of a sudden there's a conflict. Specify the language if that's relevant. And something else that people don't often understand, those who do international work do, loser pays the cost. The United States is the only place where it's not law all across the board that loser pays the cost. So if you decide you're going to litigate something in Germany, think twice, because if you lose, you're going to be paying the other side's cost. Where in an arbitration, you can eliminate those types of expenses, although you may have in the agreement prevailing fee provisions. But I think those are the takeaways from this: is you can't be too careful, give it more thought. And if you can liaise or develop a relationship with the attorneys drafting the agreement, have them get you involved ahead of time, so it doesn't come to you as something at the end. And, oh, what do you think? Whenever I get asked to do that, I say, okay, what's the end game here? Who's the client? Who's the customer? Who's got some more superior bargaining power? What's your goal if something goes wrong? And you really get that information from the lawyers negotiating the contract and the business unit. Any parting words for us, Judge?
I agree. And I agree with everything that you've said, so I have nothing to add to that. But it's been a pleasure being here. Rudy, it's always a pleasure doing this with you.
Thank you, Judge. Thank you, Nam, for doing this. And thank you, everyone who's participated. We had some really great questions. People want to know about the CLE materials and where they can get them. Can you enlighten everybody with that?
Sure. So an email was sent out earlier to everyone who registered, but if you did not receive it, you can email me at Peterson, that's SPEDERSEN at NAMADR.com, and we'll have them resent to you.
Good.
I've paused the recording. I'm now going to pause